Yes.
मैं या थैंक यू अनन्या। मैं पीपीटी प्रेजेंट करने वाली हूँ। आप लोग बेयर एक्ट भी साथ में रखे। डू यू हैव द बेयर एक्ट ऑफ इंडियन पार्टनरशिप एक्ट?
Ma'am, I've opened through
नहीं
internet.
है? हाँ हाँ, डू दैट, दैट वुड बी हेल्पफुल। यस किशन, ओके। So from Bear Act, if you see that we are going to discuss first chapter 2, which talks about your definition of partnership, partner, firm, and firm name. Section 4. Okay. So what it says, it is a relation between persons. Acha, by just before I start with the legal definition, could you help me to understand what is your understanding about the partnership? What do you think partnership means or partner means? So when we say that कि, okay, two brothers are going together as a partner to do certain act, like no to do to arrange a party or no any like आज बाहर कुछ outing करते हैं, तो is this we are thinking about that this statement has any reflection about partnership firm or partners? As a layman, what is your understanding about partnership firm? Is this with regard to business, or it is with regard to any kind of activities wherein two three people are doing together or more than that? Kishan, do you like to try that? Okay. So Kishan is saying that two persons agreed upon to carry any business. So that means Kishan, you are telling that for any other activities, it there can't be a partnership. It should be with regard to business. Correct? Okay, let's discuss what is the definition given in this no, section. It is a relation between persons who have agreed to share the profits of a business carried on by all or any of them acting for all. So, relation between person. What do you mean by person here? Is it a individual or juristic person, or can I say that two partnership persons, two partnership firm can also become a partner? क्या आप पार्टनरशिप फर्म को एक पर्सन बोलेंगे? प्लीज स्विच ऑन द माइक एंड नो tell your answer. That would be more helpful.
Yes, ma'am. A form can be called as a person.
Partnership firm can be called as a person. Okay. Okay. So anybody else has different answer? Okay. So I think you need to understand first what is person, and the second question is whether the partnership firm is a person or not. That we will understand from the definition. After reading the entire definition, we will conclude whether the partnership firm is a person or not. Okay, now when it is saying that it is a relation between person, it is talking about your individual person as well as juristic person. Okay, so private company, joint stock company, that private limited or a public limited company, is that a juristic person? Okay, we have already discussed this when we are doing Indian Contract Act. क्या प्राइवेट लिमिटेड कंपनी जुरिस्टिक पर्सन है? I think we need to discuss Indian Companies Act as well. Okay, fine. So your there is two kind of person. One is your human being, and another is your juristic person. Okay, so the companies, the private limited company or a public limited companies are called juristic person. So when we are saying that it is a relation between person, that means it is talking about your individual as well as juristic person. Okay, and who have agreed to share the profits of a business. So here it is saying about the profit, not about the loss. Okay, so Kishan, you have given answer that they might agree to share the profit or losses. No, they should agree to share the profit only. It is not saying about that loss. Okay, of a business. So it means the partnership, when we are talking about the partnership, it should be for the purpose of business and not for any other purpose. So when we are saying that two brother is becoming a partner to arrange a party or going for a trip as a partner, that is not a partnership. Okay, when we are saying when we are saying partnership as per Indian Partnership Act 1932, it is for the business and not for any other purpose, and carried on by all or any of them acting for all. This is very 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 important. Okay, uh, carried on by all or any of them acting for all. That means that all the partners either doing the business together or any of them doing it for other. This is talking about your mutual agency. Okay, wherein every partner is principal as well as an agent. When I say that every partner is a principal as well as an agent, what do you mean by that?
Ma'am, each of them act as a agent and principal for each other. Like one is acting on the acting for everyone.
Correct, Ananya. So when I'm saying that A, B, C are partners running a firm, ABC firm. Okay, in this, if A is purchasing certain goods for the business, that means he's acting as a agent at that time for whom? For rest of the for A and B. Right, for B and C. So B and C, that time, whatever the act A is doing at that moment, that act by that act B and C is also bind by it. Okay, so at that moment A is agent and B and C is principal. And when B or any other work B or C is doing, then at that moment B and C is an agent and A is becoming a principal. So both the status of agent is like the agent is both principal as well as an agent. Okay, so carried on by all or any of them acting for all. Now person, okay, so relation between persons. So if I say that uh, uh, we have just discussed that it should be relation between persons. The person means individual or a juristic person. Okay, so when I say that Mr. A and the XYZ Private Limited wants to form a partnership firm, is that possible? क्या क्या मिस्टर ए और एक प्राइवेट लिमिटेड कंपनी पार्टनरशिप फर्म फॉर्म कर सकती है? यस, कर सकती है ना, बिकॉज वी जस्ट डिस्कस दैट a juristic person can be a partner in a partnership firm. But whether a HUF is a partner, HUF is a juristic person or not? Hindu undivided family.
No, ma'am.
Correct, Ananya. So a Hindu undivided family and any individual cannot form a partnership firm. Okay, and we have discussed in Indian Contract Act that your partnership firm is not having a separate legal entity. So that means that if two partnership firm wants to form a partnership firm, like ABC partnership firm and XYZ partnership firm want to form a partnership, say uh, mm, PRI. Okay, so is that they able to form that firm? No. So because ABC firm and XYZ firm is both is not having a separate legal entity in the eyes of law, so they are not called as a person. So that's why they cannot form another partnership firm. But if ABC in ABC firm, there is three partner A, B, and C. Okay, and in XYZ firm there is three partner XYZ. All these six individuals can form another partnership firm called PRIY firm. Okay, now we have discussed that HUF and the individual cannot form a partnership firm, or HUF cannot form a partnership firm. But can a Karta and any other Karta of HUF and ABC, these three individual, can form the partnership firm? Think, क्या करता HUF करता जो है HUF का वो एक पर्सन है या नहीं है? Karta is an individual or not? He is an individual, right? We have discussed that HUF is not having a separate legal entity. HUF is not a person, but Karta is a person, right? He is an individual, so he can enter into a partnership as an in his individual capacity. So ABC plus that the Karta of the another Karta of HUF can enter into a partnership in his individual capacity. But that doesn't mean that HUF is entering into a partnership. When we have discussed that ABC firm and XYZ firm cannot enter into a partnership, but the partners can form another partnership firm, right? uh, partner who is into ABC partnership firm can form another partnership firm also, numerous partnership firm also. There is no such no limitation. Okay, person who have entered into partnership with one another are called individually partners and collectively a firm. That's what when we are saying that the partnership firm is not having a separate legal entity, because from this line, okay, because each person who have entered into a partnership is called as partners. Okay, but they all collectively called as firm. A, B, C, when they are collectively, see, we have discussed in Indian Contract Act in one scenario that can individual run their own business. Say if I say that I as an individual filing an ITR, right? And I have a salary income, but can I have a business income? Yes, I can. And being my name is Priyanka, but I can also no have another firm called PRY firm, PRY creations. So that is an individual. As an individual, I can also open a individual firm. Okay, I'm not talking about the partnership. I'm just saying the individual running business, a proprietorship business. But that is again that income which PRY creation is earning, that is clubbed in my ITR itself, because that PRY creation is not having a separate legal entity, and it has the entire income, or the profit or loss will be clubbed in my will be shown in my ITR itself, and not as PRY creation. Okay. And most importantly, in proprietorship concern, there is no separate PAN. But however, in our income tax act recognize it as a separate legal entity, and that's why for only for the purpose of income tax purposes, partnership has separate legal entity, but not for any other purposes. Okay. So when we are saying here person, so and that's why partnership firm is not a person, because all partners are collectively called as firm, and it has no separate legal entity. That firm has no separate legal entity apart from that, all the partners cumulatively. Okay. And the name under which their business is carried on is called as firm name. Whatever name you can give, ABC can give ABC creation as a ABC firm as a partnership firm, or they can give no upahar firm, partnership firm, can also, they can name anything whatever they desire to. Okay. Now from the definition, if you notice, these are the elements of partnership. One is your association of two or more persons. Because obviously one reason is that one person cannot be a partner in a partnership firm, right? It has to be two or more persons. So only person, this we have discussed, only person recognized by law can enter into a partnership. That means a partnership firm cannot enter into a partnership. HUF firm, HUF cannot enter into a partnership. But private limited or a public limited company can enter into a partnership because it is a juristic person. Okay. Uh, can partnership firm be a partner? Obviously not. Can minor be a partner? क्या माइनर पार्टनर बन सकता है? क्या माइनर किसी कॉन्ट्रैक्ट में इंटर कर सकता है? No, Kishan. So with by
No, ma'am.
yes, yes, by applying this itself, you can tell that na कि minor cannot be a partner. But can minor be a beneficiary in any contract?
Yes, ma'am.
Yes. So that means that your minor may be admitted to the benefit of partnership, but he cannot be a partner, right? So by just applying Indian Contract Act also you can answer these things. But whenever we are entering the minor in a no, for the for benefit also, it should be with consent of all the partners in the partnership firm. So our understanding is minor cannot be a partner, but he can be admitted for a benefit in the partnership firm with the consent of all the partners. Now, what is the maximum number of partners? This number is not provided in anywhere in the Indian Partnership Act. But when you visit to your Companies Act, there you will find it that the maximum number of partners is provided as 50 in any partnership or associations. Okay. Now, uh, must be result of an agreement. So what do you mean by agreement? What do you mean by agreement? It's like we have discussed entire law, and then the first class itself you are not able to tell. मैं ठीक से समझा भी रही हूँ या नहीं? एग्रीमेंट का मतलब क्या है?
It's a contract enforceable by law.
No, Sanket. Agreement is simply offer, acceptance, and consideration. And when we include enforceability by law, then it becomes contract. So agreement enforceable by law is called as contract. But contract enforceable by law is not. We will not. There is no such definition. Uh, okay, contract enforceable by law is contract. I mean, you are trying to say that agreement enforceable by law is contract. But for agreement, there is only three component required: offer, acceptance, and consideration. It is not necessary that it has to be enforceable by law. Okay, so by why I'm we are discussing about the agreement, because it should be offer plus acceptance. Consideration is there obviously, but uh, you cannot, no, by just means you cannot by yourself include any person as a partner. That person has to accept that he also want to be a partner in that partnership firm, and obviously for the consideration, because there is a sharing of profit that is there, right? So let's not discuss about that right now. So by agreement I am trying to say that it should be voluntarily. It cannot be enforced by somebody else, or you cannot just by giving a name that okay, I want to be this Shahrukh Khan as my partner, and the Shahrukh Khan has not no given your acceptance, acceptance to become a partner of you. You cannot make him a partner. So there should be a voluntary and contractual no agreement between you and the other person whom you want to be a partner, whom you want to make a partner. So entered into by all person concerned. So every person should be given a voluntarily, should entered into an agreement to form an partnership firm. Okay. And as we discussed in the Indian Contract Act, that it it can be oral, it can be written, it can be implied. Like implied is by through conduct. So if I say that A, B, C, all these three person are brothers. Okay, they have this HUF business. Matlab they have this family business, and they sold this family business, and from by selling that family business they got suppose say 10 lakhs. And now this ABC has started, the earlier they have this grocery business. Okay, now they have sold this business and got 10 lakhs, and from this 10 lakhs they have started a restaurant. Now tell me whether this ABC are partners or they are still a HUF. This restaurant is your HUF business or a partnership firm? So we have discussed in Indian Contract Act that through conduct also you have to decide whether there is an agreement or not. Okay, so we have understood that that through implied way also a person can enter into an agreement, right? So if you see that they have sold the business and they have no formed another your another business which is uh, not your HUF business, right? They have not gone they have through their conduct started a new business. So this new business you can understand that this is a partnership business itself. Okay, it is not an ancestral or HUF business, because a partnership firm can be formed between a husband and wife, can be formed between brothers. There is no such no restriction that ki particular relative cannot be entered into a partnership business. So through conduct you can understand that this is also a partnership business, and this, and they have sold HUF business. If they have continued the HUF business or no or extended that business, then that might be an extension of HUF business itself. But it is completely altogether new business. Through conduct we can understand that this is a new partnership business. Okay. Third is organized to carry on some business. So it should be some business. It can't be for any other purpose. Like they all these three brother has decided with this 10 lakh rupees, let's have a world tour. Okay. So this is not a partnership here. Okay. And it should be for some business. So business may be for any occupation, trade, or business or any profession. सो इट इज नॉट नेसेसरी दैट कि आपको रेस्टोरेंट या फिर ग्रोसरी बिजनेस खोलना है. आप कोई मतलब कोई क्रिएटिव काम भी कर सकते हो, कोई प्रोफेशन में भी जा सकते हो, राइट. सपोज मतलब as in photographers, all these three becomes a photographer and formed one creation. Okay, ABC creations. So it is not necessary that it should be having a goods, it can be a services. Okay, and it should have the acquisition of gains. So there should be the intent should be to earn profit and share profit. Okay, so if all these three ABC enter into a business, but they agree to share losses, not to share profit, that means will you consider it as a partnership firm? See what it is written here. They must have agreed to share the profits. So agreement to share the profit is must. Whether they agree to share losses or not, that is irrelevant. They should agree to share profit. If they are not agreeing to share the profit, there is no partnership firm. So if I say that A and B agree to share profit, but C agree to share losses, then there is a partnership firm. Again, my answer will be no. All of them must agree to share the profits. If I say that only one person is taking profit and the other person are just taking the remuneration, then also there is no partnership firm. Okay. This is what we have discussed. Can one partner has all profit? No. And other working on salary? It is not possible. What if out of 5 partner, 3 share profit and 2 losses? Then also there is no partnership firm. The business must be carried on by all or any of them acting for all. We have a prima facie understanding of this. We will discuss it in a detail because this is very, very important. Okay. Okay, so we have discussed that partnership firm is not having a separate legal entity, right? So you can also visit this CPC order 21 rule 50 and CPC order 30 rule 1. There also it mentioned that then there also it is not talking about the partnership firm. Where any kind of action is required to be taken, it is against the firm or against the partner only. Okay, and not the partnership firm, because partner the law doesn't recognize partnership firm as a separate legal entity. From this also you will have an understanding. Please read this. Okay, and again when we are saying that it is partners and there should be an agreement, so agreement means it should be that voluntarily all of them agree to enter into a partnership firm, right? So offer and acceptance should be there. So this is what right to choose partner. So the other person also willing to be a partner, and you also have a right to choose partner. So if I say that like in case of ABC partnership firm itself, if I say that upon the death of the C, can his son become a partner automatically? No, right? Because it is not HUF wherein the status by one person become no has right through status. The partner has to be chosen by all the partners existing in that firm, and the other person who is that son, he is also required to accept to become a partner. But in HUF, can anybody who is no becoming a member of or co-partner in HUF is giving and her his or her acceptance to become a member in HUF? No, right? Just by birth he get that status of co-partner. But in case of partnership firm, it is not like that. So if the father or mother who is a partner in that partnership firm, upon his or her death, his son or daughter will not become a partner. Okay. So please answer this. Co-owners who share amongst themselves the rent derived from piece of land are partners. See, we have understood, in order to decide or conclude whether it is a partnership or not, there are certain essential elements which we have just discussed, that there should be an association of two or more person. There must be, that association must be result of an agreement. Okay. And all of, which is, that agreement must be entered into by all the partners, right? And the third is sharing of profit. And the fourth, your fourth point is, it should be for some businesses. Okay. And the fifth is your mutual agency, right? If all these five elements are there, then only it is a partnership firm. If any of this component is missing, then it is not a partnership firm. So what you are seeing in this, the co-owners means there is a one property in which A and B, say, I and Monita, if I'll just take your name also. So Priyanka and Monita are co-owners of one property. Okay. Who shares amongst themselves the rent derived from piece of land. So from that, we have rented that that property, and from that we are, say, rupees 1 lakh we are getting as a rent. So we are receiving that, we are just since our status is a co-owner, we are, that rent amount is divided between Monita and me. So Monita is getting 50,000 and I am getting a 50,000. So do you think, is there any kind of agreement to enter into a business, or any like any mutual agency has been formed? Like if I am doing anything for because of that act, Monita is getting bind from that act. Any kind of mutual agency is formed. So just by, no just by sharing profit also, you cannot decide that there is a partnership firm. Or just by seeing that there is an association of two or more person, but there is not any other element, then there is no partnership firm. All the five element must be there. And from all these five element, the mutual agency is the foundational stone. Okay. Which will help you to know, as a guiding light, to understand whether there is a partnership firm or not. Because what happened, we have just discussed that partnership firm can be formed either by your written, or by oral, or by implied manner. So if there is no written document, and you have to decide whether there is a partnership firm or not, how you will decide? Through this test only, whether all the essential element is there or not. Okay. The business must be carried on by all, or any of them acting for all. So it is a binding contract of mutual agency between the partners. This statement means that mutual agency itself, each partner carrying on the business is the principal as well as an agent for all the partners. When agent, when he can bind the other's partner by his acts. So when I said that Mr. A went to purchase, Mr. A has purchased certain goods for the business, then he is binding the other partners in that transaction. So the seller who has sold goods to Mr. A can recover that amount from B or C also. Right? It is not necessary that he has to recover that amount from A only. Okay. When principal, to the extent that he is bound by the acts of other partners. So in this, what happened, when A is purchasing the goods for the business, then B and C is bound by the act of Mr. A, right? So that time B and C becomes a principal. So true test of partnership is mutual agency rather than sharing profit, which we have just discussed, that in co-ownership, there the profit, the person is receiving, but there is no agency. So it is not a partnership firm. If no mutual agency, then no partnership. Okay. So this is one landmark judgment, KD Kamath and Co. Supreme Court held that two essential conditions to be satisfied for a partnership firm, that there should be an agreement to share the profit as well as the losses of the business. The business must be carried on by all or any of them acting for all. In this judgment, this has been concluded. If one partner, so this is one question. Okay, if one partner operate bank or borrow money on behalf of partnership firm, is this destructive of the theory of partnership? No, because anyone can be one only in the partnership firm. Only Mr. A will be doing all the management work, and the B and C might be sleeping. They are not doing any act, but they are still bound by the act of A, right? So even if one partner is operating the bank, or he's doing all the business transaction, or entire business is done by Mr. A itself, then also it is not destructive to the theory of partnership. The partnership still exists. Okay. Okay, in this example itself, wherein A made certain purchases, the third person, the seller, can recover from whom? What are the options what all options that seller has? The seller can recover the amount from A, can recover the amount from B, can recover the amount from C, right? This is another case law. Santi Ranjan Das Gupta versus Desirayan Murjamul. Parties not retained any records of terms and condition of partnership. So in this, whether in this the Supreme Court is deciding whether there is your partnership relationship exist or not. So in that, the partners in that case, the parties has not retained any records of terms and condition of partnership. There is no written records. Okay, partnership business has maintained no accounts of its own. So there is no financials or any kind of business accounts has been maintained. There is no bank account also, and they have not given any kind of written intimation to deputy director of procurement with respect to newly created partnership. So from all this, the Supreme Court has concluded that there is no partnership between the parties. Okay. See, for partnership firm, it is not necessary that it has to be compulsory registered. Even without registering the partnership firm, also a partnership firm can be formed. So this you can read it, section 6. And wherever any kind of case come in the exam, wherein scenarios given by the by examiner, wherein true test of partnership is required to be no, judged, in that case you have to refer section 6 and provide this case law also, KD Kamath and co, and the other case law which we have discussed, and discuss all the essential element of the partnership, and and accordingly you just after writing this no conclusion, you will have the answer, and you just apply this concept in the fact of the case. I think in 20 in this exam also it came. Okay, so what is the difference between partnership versus company? So we have already concluded that partnership firm is not having a separate legal entity. However, your joint stock company is having a separate legal entity, and that has been also given in the Salomon versus Salomon judgment. Agency. So we have discussed that there is a mutual agency in the partnership firm, but do you think there is an agency in the company? Obviously not. Members are the your owners, right? Members are the owners of the owners in the company. So member is not an agent of other members or of the company. His actions do not bind neither your members nor the company. Okay. Distribution of profit. In this we have discussed that sharing of profit is must, right? But in case of joint stock company, the sharing of profit is not compulsory. So what do you mean? How the profit is distributed in company? By declaration of dividend? But declaration of dividend is mandatory, that the company has to declare the dividend if there is a profit in the company. No. So if the company doesn't want to distribute the profit, they can the company cannot. But in case of partnership firm, it is mandatory to have a sharing of profit. Extent of liability. See, since it has no separate legal entity, that itself decide that the partnership firm has unlimited liability. Because if anything go wrong, then the third party can recover that loss amount from the partner's individual properties also. Okay, so unlimited means it is not only the partnership firm certain assets or any revenues which are able to to bear that loss, but even the partner's personal assets are also into that. And from that personal asset also it is to be recovered. But in case of company, it is not so. So if the company is limited by shares, so the only the unpaid amount, the members are required to give only the unpaid amount, no, in order to adjust that losses, only the your unpaid amount of shares will be given. And the members personal assets are not into risk. Or in case of guarantee company limited, in case of guarantee company, it is limited to the amount for which agreed to be liable. Because obviously the guarantee amount, whatever the amount has been guaranteed, the member has to give that guaranteed amount and not anything else. Okay, so how many members? We have already discussed that in case of partnership firm, it is limited to 50. But in case of private limited company, obviously minimum is 2 and maximum is 200. However, there is a new concept which is one person company, wherein only one member can be also possible. See, don't confuse with the member and director. Directors are different. Okay, and members. A member can be a director also. A director can be a member also. But it is, and member and director can be a separate person also. It is not necessary that the person who is member must be a director, and vice versa. Transfer of shares. So in case of partnership firm, whatever the shares in profit which has been agreed in the partnership firm cannot be transferred without the consent of all the partners. But in case of private limited, it is completely depending upon what is the article of association is saying. So if the article of association is restricting, it cannot. So you might confuse with that okay, we understand that in case of listed company, public listed company, the share can be easily transferred. But how in the private limited company the shares can be transferred? Anybody has any idea about that? I give it as a task. Okay, think about it. Hmm. Management. In the absence of agreement in contrary, all the partners are entitled to participate in the management. So we just discussed that only one person can be also having the responsibility of all the managerial work of the partnership. Right. So if in the agreement they have decided that this Mr. A is going to manage the entire partnership firm and B and C is only the sleeping partner, that is also a possibility. But if nothing is mentioned in the partnership firm, then all the partners are entitled to participate in the management. And but in case of private limited company or public limited company, members cannot participate in the management. That responsibility is with the board of directors. Okay, registration. So obviously partnership firm can be formed without registration, and with registration both can be possible. But in case of company, joint stock company, whether it is a private or public, it must be registered. The incorporation procedure is there through Ministry of in MCA site, we have to incorporate that. Okay, winding up. So it can be dissolved anytime if all the partners agree. So even for the for dissolution also there is no much no complication involved, and it also depends upon how you have entered, how the terms has been decided by all the partners. That how the dissolution will be done. It has some legal formalities has been provided. Then it should be according to that. If it is not, then just by no giving a notice to all the partners, the firm can be dissolved, or on happening of certain events, the firm can be dissolved. Okay, but in case of joint stock company, it should be through either by NCLT or its name will be struck by ROC. There is a process. Duration, it's again decided upon the terms what is mentioned in the partnership firm. So if it is a partnership firm at will, anytime, today morning I have formed the partnership firm, in evening I feel that no, I don't want to run this business, and I can dissolve it. But suppose if it is a partnership firm for a duration, fixed duration, then upon the expiry of fixed duration, the partnership firm will be dissolved. But suppose if after the fixed duration also I want to continue the partnership business, then I can still continue and it will be converted as partnership at will. Okay. But upon in we have also understood novation in Indian Contract Act. Okay, so we just understood that partnership firm is an a voluntary contractual contract, right? It is an agreement between two or more person. So that means that if any changes happen between the partners, right? So suppose one person has died, then that means what happened, uh, that contract will be dissolved, because the contract has been entered between A and B and C. C died. So what happened? Novation happened, right? A and B remains. The party is not there. The C is not there. So that initial contract is dissolved and the new contract has to be formed. A and B, right? If they want to continue. Okay, but in the terms, while making the partnership firm itself, they have mentioned that if any of the person died, the partnership firm will continue. Then it will not dissolve. So it completely depends upon what the terms has been agreed upon at the time of entering partnership. But if no terms has been entered, then on case of death, on case of retirement, or on insolvency of a partner, it result into dissolution of partnership by applying the concept of novation. Okay. And the in case of company, obviously it has perpetual succession. Now partnership versus club. So the very important difference is partnership is formed for earning profit, but club is for some beneficial purposes. Like you have some seen that there is a health club. Okay, there is a medical club. So it is for certain purposes, not for earning profit. Relationship is your in partnership firm, persons are all the person who are forming the partnership firm are called partners, but in this club they are called as members. Okay. And there is a mutual agency in partnership firm, but in case of club there is no mutual agency. Okay. Another is your interest in the property. So since partner and the partnership firm is not having a separate no, it's not a separate, so whatever the partnership firm is owning as an asset, that is also of partner cumulatively, right? But in case of club, that is not so. A member of a club has no interest in the property of the club, but partner has interest in the property of the firm. Dissolution. So in case of club, a change in the membership of a club does not affect its existence. Any person can become a member, can and can resign from that. Like if that person is not paying any kind of no formality is there to become a member, if that formality is not fulfilled after a certain period of time, then that person is not a member. Like any condition will be there, but that doesn't mean that club will not remain. Club will still remain, but in case of dissolution, but in case of partnership, it is not so. So we have discussed about partnership versus HUF. Okay, so a few of the pointers we have discussed. So can anybody tell me what are the difference? What exactly the difference between partnership and the HUF?
Ma'am, in HUF, just by birth, a person can get the status of the co-partner, whereas in partnership, it is the consent of the both parties that is required for them to be partners.
Very, very correct. So partnership is created by an agreement, but HUF is by status. Very correct. Any other point? Okay. So let's discuss. So mode of creation is already no, uh, discussed. Now death of member. In case of death of a partner, it ordinarily leads to dissolution of a partnership, but in case of death of member, HUF does not give rise to a dissolution of the family business. It means like whether any new person is no included in HUF by birth, or if any person is dying, it is not no dissolving the status. It is not dissolving the HUF itself. But in case of partnership, it is right. If any person is dying, that means it is also resulting into dissolution of partnership firm. If any other agreement has not been no there uh, at the time of formation of the partnership firm. Another, management. All the partners are equally entitled to take part in the partnership business. But in case of HUF, all this management right is with the Karta. And if you will read Hindu law, there you will find it out that in 2005 amendment, through 2005 amendment, now even a female member can be a Karta. Earlier it was only a male member. Okay. So continuity, this we have already know. HUF continuity till it is divided. So if anybody went for a partition, then in that case HUF status will be dissolved, and but on not on the death of the member. Authority to bind, every partner can by his act bind the firm, mutual agency. But in case of Karta, in case of no HUF, only since Karta has authority to contract for the family business, the act of Karta uh, is binding everybody, but not the binding every other member in the family. Okay, but not the act of the members of the family. Okay, liability is unlimited here, but in case of HUF, liability of Karta is unlimited, but co-partner liability will be only limited to the extent of no share in the profit of the business. Governing law, Indian Partnership Act 1932. In case of HUF, it is Hindu law. So minors capacity we have already understood in case of partnership firm, but in case of HUF, minors become a members of the ancestral business. See here it is ancestral business, not self. Suppose if any person, no, your suppose father is having an ancestral business as well as his own business. So on so only any minor on upon the birth, that minor is having no right becomes a member on the ancestral business and not in the self occupied property. That uh, uh, that will be only upon the death of the father and not before that. That you will read in the Hindu law. Number of member, in case of partnership it is 50. In case of no HUF, there is that is unlimited. Okay. So partnership is for sharing of profit, but it is for association is for social cause. That is the key difference. And it is not necessarily that the motive should be to earn profit or not to profit or share profit. Okay, that's the key difference between association and partnership firm. Okay, so we have discussed about partnership at will. Kinds of partnership we have already discussed that there is a partnership at will. There can be a partnership for fixed period. Now this is as per the duration. Okay, so if the duration is not fixed in the partnership firm and we have decided that it is at will, so uh, so it means that uh, any partner can dissolve that partnership firm by giving a notice to all of the partners. But in case of partnership for fixed period, only it is dissolved after completion of the fixed after the completion of that fixed period. But if the partner decide to continue after fixed period, then it becomes the status of partnership is changed from partnership for fixed period to partnership at will. Okay, and what do you mean by particular partnership and general partnership? Can anybody think of? पार्टिकुलर पार्टनरशिप क्या हो सकता है किसी पर्टिकुलर पर्पस के लिए, राइट? बट जनरल पार्टनरशिप क्या हो सकता है कि इसमें कोई भी जनरल बिजनेस कर सकते हैं। पर्टिकुलर पार्टनरशिप में हम सोच रहे हैं कि हाँ रेस्टोरेंट बिजनेस करना है तो हम सिर्फ रेस्टोरेंट बिजनेस ही करेंगे। बट जनरल पार्टनरशिप में हम कोई भी जनरल बिजनेस करने के लिए हम पार्टनरशिप फॉर्म कर सकते हैं, राइट? दिस इज व्हाट इट इज। ओके, So kinds of partners, we have no these many types of partners you can think of. One is your active partners, another is sleeping partner. Active partner by its name, no, it reflect that the person must be in doing all the managerial management, taking care of the management of the firm, right? He's an active one. He act as an agent of other partner because he is only managing the business. So he is an agent at that time, right? Whenever the person who is acting or who is doing certain work for the firm, that means he is an agent for other partners, right? uh, and when since he is since he is an active partner, so at the time of his retirement, public notice to be given must. Okay, because everybody should be aware about that he is retiring. Sleeping sleeping partner by name itself, it's reflect that he is not active participant. Okay, so since he is not active participant, that means the public notice is not much required, because other person is also not aware about that, okay, this person is a partner, or if he is aware also, he is not dealing into it. So why the public notice is required? So that the person, the other people who are dealing with the partner, or no, they must be aware that he should not be dealing, because his status as a partner is not there now. Okay, since the sleeping partner is not active partner, so public notice is not required. And his insanity does not dissolve partnership. In case of active partners, if the active partner is insane, then it dissolves the partnership firm. Okay, but in case of sleeping partner, his insanity does not dissolve partnership. And but very much important is that he's liable like any other. So his liability will not be decreased because he is a sleeping partner. He is liable like any other partner, like any active partner. Okay, so if any loss happened, so he will be liable also in that. Suppose if the active partner is taken a loan for the business, and the borrower is now asking uh, money, so that person can ask money from sleeping partner also. It is not necessary that he has to ask from the active partner. Okay, nominal partner. So nominal partner is just giving or his name as a partner. He's not in profit sharing. He's not even having any liability in that business. And his insanity will also not dissolve the partnership. But he suppose if I and no you is forming a partnership firm, and we approach Shahrukh Khan that ki you become a partner in our firm. So he just by his name in our partnership firm, being a partner in our partnership firm, our no business has more reliability, right? In the market. So what happened, he's just giving his name. So when he's retiring, the public should be aware about that he's not there as a partner, right? Partner in profits only. So there cannot be partner in losses only. Okay, partner in profits only is possible. A person can share profit, but might not be sharing losses. But if in the if in the terms of partnership agreement, nothing is mentioned about how the loss will be shared, that means loss will be shared as the way the profit will be shared. Okay, so entitled to share profit only, not liable for losses, liable to third parties for all acts of profits only. Okay, incoming partner. What do you mean by incoming partner? So there is an existing firm, and now there is AB is a partner in that firm. Now he wants to no include C as a partner. So this C is an incoming partner. Okay, so person who comes into a firm already in existence with the consent of all the partners. So incoming partner should come with the consent of all the partners. And at the time of he becoming a partner, any act done in that partnership firm before his admission as a partner, for that he will not be liable. He will liable only for those act which is done after his admission. Outgoing partner. So outgoing can be by any mode. Okay, it can be by retirement, it can be by expulsion, it can be by insolvency or death. Okay, so in case wherein any partner is outgoing, that time the public notice should be given. Otherwise whatever the act, even if the public notice is not provided, no public notice is not given, then then that outgoing partner is still liable even after his retirement, or even after no he becoming an outgoing partner, he will be still liable for all the things happening. So but not for the profits, only for the liability part. So it is, the public notice must be given after his no becoming a outgoing. That's what it is written: remains liable to third party for all acts of the firm until public notice is given of his retirement. Okay, what do you mean by sub partner? Does it sound like sub agent?
Yes, ma'am.
Hmm. Yes. So partner agrees to share his share of profit in a partnership firm with an outsider. Such outsider is sub partner. So he is not basically, that person is only sharing his profit. Okay, he, that outsider is not having any relation with other partner or other your no uh, or with the firm. But in case of agents, sub agent, if that sub agent is no as if the principal is given consent to that, like if suppose that there is no terms that agent can have sub agent, at that time you can relate it that he has no no he's very similar to uh, but if the consent is there, that time you cannot relate it with the sub partner, correct? So if principal has given a consent that agent can have sub agent, that means if sub agent is dealing with third party, then with third party can can sue principal. Just see what is the difference between sub agent and sub partner. Okay, try to no, to analyze what exactly सब एजेंट के केस में हमने दो सिनेरियोज देखा था, जब प्रिंसिपल ने अलाउ किया था सब एजेंट रखने के लिए, और जब प्रिंसिपल ने अलाउ नहीं किया हुआ था सब एजेंट रखने के लिए, तब उस केस में क्या राइट एंड लाइबिलिटीज रहते हैं ना, कैसे रिलेशंस रहता है प्रिंसिपल एजेंट सब एजेंट और थर्ड पार्टी के बीच में. ऑल दिस यू जस्ट नो ट्राई टू राइट इट डाउन एंड प्लीज शेयर ओवर email, and what how it is different from sub. Anyways, there is no relation between sub partner and sub agent, but it just sounding that. But when in that case, if but they, you can relate it when the sub agent is not having your no when the principal has not given a consent to have a sub agent, because from this you can understand that neither has right against the firm nor he liable for the debts of the partnership firm. Okay, partner by holding out, we have many a time we have discussed this partners by holding out. Please explain. That some person is representing himself as a partner but he is not a partner, right? So he knowingly permit himself to be a partner. So in that transaction, suppose if A has taken a loan by representing no uh, Shahrukh as a partner of his firm, and Shahrukh has also knowingly permit himself to be a partner. Okay, even if he is not a partner, that means in that transaction, if the Mr. A has not paid the loan amount, then Shahrukh will be responsible to pay that loan amount, right? Because why? Partner by holding out. Okay, so let's no uh, see the partnership act from the okay. So what the preamble is saying: an act to define and amend the law relating to partnership. So from this, will you able to say that partnership firm is an exhaustive or non-exhaustive? In most of the preamble you have seen the word codify. So when the codify is mentioned, we understand that this act is an exhaustive act. But when it is not mentioned and it is saying that what an act to define and amend the law relating to partnership, okay, by this also we understand that it is non exhaustive. And by reading your 2 subsection E, see, expressions used but not defined in this act and defined in the Indian Contract Act shall have the meanings assigned to them in that act. मतलब अगर कुछ एक्सप्रेशंस हैं आपके इस एक्ट में नहीं लिखा हुआ है पर वो डिफाइन किया हुआ इंडियन कॉन्ट्रैक्ट एक्ट में, तो आप इंडियन कॉन्ट्रैक्ट एक्ट में जाके उसका मीनिंग देखिए। तो इसका मतलब क्या हुआ कि ये एक्ट जो है अपने आप में एग्जॉस्टिव नहीं है, राइट? ओके, वी हैव अंडरस्टूड बिजनेस, एवरी ट्रेड ऑक्यूपेशन एंड प्रोफेशन. Third party used in relation to a firm or to a partner therein means any person who is not a partner in the firm. Correct? Uh, okay. So by this, what do you understand? This partnership firm act, sorry, partnership act is your retrospective or hybrid, or what you will understand? Prospective. What do you think? If in prelims it will, if any questions comes like Indian Partnership Act is a retrospective act, or it is a prospective act, or it is a hybrid act, then what you will choose? What do you mean by retrospective? What do you mean by prospective?
Ma'am, retrospective means it was applicable from a date in past, which means like it occurred before a new rule was there in its place.
Mm-hmm. ओके, तो पार्टनरशिप फॉर्म, पार्टनरशिप एक्ट आपको क्या लगता है, ये रेट्रोस्पेक्टिव है या प्रोस्पेक्टिव है?
Ma'am, I guess it will be hybrid.
हाइब्रिड का मतलब?
Ma'am, applying both retrospectively and
Correct.
prospectively.
Definition of hybrid is very correct. That certain provision it is mentioned that okay, this provision will be no applying retrospective, then you can say. But otherwise, if it is not provided like that, then it is. You have to read it section 74. Okay, section 74 will be guiding principle whether this act is your prospective or retrospective. Okay, this is a task.
Okay, ma'am.
Okay. हाँ, but for a general understanding, if any act which is coming as a clarifactory act, like कुछ पहले से ही लॉ है उसको क्लैरिफाई देने के करने के लिए कोई एक्ट आता है, तो ऑब्वियसली वो रेट्रोस्पेक्टिव होता है क्योंकि वो क्लैरिफिकेशन दे रहा है, राइट? बट कोई लॉ जो है वो रेगुलेटिंग नेचर का है, रेगुलेटरी नेचर का है, हाँ, सो और कोई सब्सटेंसिव लॉ है, तो वो मोस्टली आपका क्या होता है, प्रोस्पेक्टिव होता है, अनटिल अनलेस इफ इट इज नॉट मेंशन इन द एक्ट इटसेल्फ दैट इट इज रेट्रोस्पेक्टिवली अप्लाइंग, right? If it is not mentioned then it is prospective only. So go through, please read this section 74, that will help you to understand saving clause. सेविंग का मतलब क्या होता है? सेविंग का मतलब आता होता क्या है? आप मतलब जब आपने हमेशा एक एक्ट में देखा होगा एक सेविंग क्लॉज रहता ही है ना, मोस्टली? Okay, so I am giving this also as a task. Go through it, understand what do you mean by saving clause, and no whether this act is your retrospective, hybrid, or prospective, understand it from section 74. That will be helpful to you. Okay, and if in case if you're not able to conclude, you can raise your question. So I'm thinking of ending the class today. If anybody has any question from today's class or previous class, or
Ma'am, in previous Sales of Goods Act class,
Mhm.
you had told that to research on if software is a good under Sales of Goods Act. So, ma'am, I have found that it can be a good, whereas in English law it is not necessarily a good.
yes, it is basically no service, because its license to use will be is given. So it is confusing actually. So you just because what is happening, see, in that case you are not receiving any kind of delivery. How the delivery is happening? You're just giving a license to use. So soga is not applying in the software case.
Okay, ma'am.
You have any other opinion, or if I'm you are contradicting with my answer with the research you have, then I'm free to no, learn from you. As far as my understanding says that soga will not apply in that. So
Ma'am,
what's
there
your
is like, ma'am, there are like these kinds of confusion that sometimes the court declares that in certain cases it cannot be applied, and in other cases it upholds that yes, it can be applied.
Yes, yes, it is having a gray line. So if you have no done certain research, just share with me, and then I will give you a better no answer over it. Let me give you my email id. If the one who is doing research is free to no, all the questions which I am raising, if anybody is like Ananya, you have no done research over it, so I'm really happy that you have put an effort over it. Contact.finlegal. Just a minute. If all the queries which I have raised in the no classes, if you will provide me the answers, I'll provide you my number over this, and over in email, and then any kind of queries you have with regard to the preparation, I'll be happy to support. I mean, I will give you all the answers, or any kind of queries which you have, will you will be having access to me. And I'm
Okay,
really,
ma'am, I'll
really
definitely
happy, Ananya,
contact
that you
you.
have opened. Yes, just solve all the queries which I have raised, no, in the classroom. Try to think whether it's wrong or right, doesn't matter. At least have your what see, laws. So you will even learn what, as a good teacher or anybody who is no. The important is how to read, and no ignite the curiosity to no have questions in mind. So just reading this, just only if you suppose if I'm reading a person, relation between person, you need to think what do you mean by person, whether a partnership firm is a for person or not, right? So because in the interview you will not going to get a vanilla question, like the whatever the law is there. You're just no just giving the exact you need to have an understanding over. They might ask anything, and mostly they are trying to do that only. So when you are raising this kind of question in your mind, you are very close to that, because the process is not only to clear means you have to also clear interview, and it is very uncertain. You don't have any previous year question for interview. Okay.
Yes, ma'am.
Okay. Thank you all, thank you very much. And Ananya, I'm really very very impressed that you have worked upon. Thank you for working on that. Okay, bye bye, good night.
Thank you, ma'am.